list, but I'm not going to read everything. I am just going to go over the trigger list and the definitions as quickly as possible. So without further ado, if you want to pause the video and read off what I wrote, you can. And actually, I'll make it bigger so that you can see it better. So with this list I created, there is a main trigger list, and it is going to be here. The main trigger list is each teacher did select dignified, glorified, intentional, stylish learning methods people think particularly delightfully rewarding. So you're going to write down 10 points. Some of them will have more than one initial. It's going to be 1E, 2T, 3DS, 4DGI, 5SL, 6M, 7P, 8P, 9D, 10R. Just to let you know, there are other checklists out there that aren't as detailed as mine, and a lot of them just jump right into intentional torts. Some of them have 13 or 14 sections. This is the way I broke it apart. This is my mnemonic that I created, so you can do whatever you want, and I created this about 3 years ago. So without further ado, here we go. E, elements. So each teacher did select dignified, glorified, intentional, stylish learning methods people think particularly delightfully rewarding. 1E, elements. Torts are a category of civil action where a person has suffered a harm from the action or inaction of another outside of any agreement between the parties. Like I said, I'm not going to read the whole thing. I'm just going to read the main points. T, 2. There are 3 types, main types, generally speaking: intentional, negligent, and strict liability types. Okay? 3, defenses specific. Okay, so here you have tort law divided between specific intent and general intent. Just, it's not the same as criminal law. It has a different nuance to it, but they categorize it. Now, a specific intent tort is where the actor intends the consequences of his conduct if his purpose is the resulting consequences. Like, I intend to give you a black eye, or I don't intend. Was it accidental or was it on purpose? Now, defenses, general intent. Well, an actor intends the consequences of his conduct if he knows with substantial certainty the consequences will result. Now, strict liability: animals, ultra-hazardous activities, abnormally dangerous activities, mind torts. These mind torts, which is 6M, is defamation, libel, slander, invasion of privacy, appropriation of likeness, intrusion upon seclusion, public disclosure of private facts, false light in the public eye, defenses. So 7 is physical miscellaneous. Okay, so that would be wrongful death, survival statutes. Now, by the way, physical can be negligent or reckless. Statute of limitations, so it doesn't necessarily need to be intentional. Now, there's a lot of crossovers with these. You'll find different fact patterns that look like a contract or a business tort, and professional responsibility, etc. So you'll have to look at that. Now, parties: vicarious liability, employment, employee, employer, independent contractors, family purpose doctrine, permissive use, belly, parent-child, additional third parties. Now, damages. Damages kind of goes without saying, and 10 remedies. Okay, so with the main elements checklist triggers, kind of broke it apart a little bit more. Tort is a civil injury. for which a plaintiff sues the defendant for damages in a breach of duty. There are 4 elements to tort law duty: breach of duty, causation, and injury. Okay? Key terms: duty. There's a general standard of duty of care in intentional negligent tort cases. It's an obligation to use due care to avoid harming another within reason. They use the reasonable person standard generally. Breach of duty. A breach in negligence indicates the defendant did not meet the standard of care. The defendant's actual conduct is compared with what is required by the standard of care. The standard of care is the defendant's conduct judged in a negligence case against what a reasonable person in the same or similar circumstances would do. The reasonable person standard takes into consideration a person's abilities, for example, if they're blind or a minor child. Causation. I'll go over causation again in the future. So 3 types of torts, generally speaking, again, are general, theories of the types, general, intentional, negligence, strict liability. So here we have intentional, okay? Now, if you want to try to remember the intentional, and I didn't make this up, I found it somewhere on the web. FACTBIT, FACTBITII, false imprisonment, assault, conversion, trespass to chattel, battery, intentional infliction of emotional distress, trespass to land, interference. So it was 2 types of interference. And I'll just read this out. False imprisonment is the intentional physical or psychological confinement of another person within fixed boundaries for any period of time which is actual and proximate cause of the injury. Beware of threats, no reasonable egress, or no duty to escape. Assault. The intentional placing of another in reasonable apprehension of an imminent harmful or offensive touching which is the actual and proximate cause of the injury. Words alone are not enough. Conversion. The intentional exercise of wrongful dominion and control over the chattel of another, which is the actual and proximate cause of the injury. Beware, mistake is never a defense. Trespass to chattel. The intentional interference with another chattel, which is the actual and proximate cause of the injury. Battery. The intentional, harmful, or offensive touching of another, which is the actual and proximate cause of the injury. Intentional infliction of emotional distress. The intentional conduct of extreme and outrageous nature, which is calculated to cause, and which does cause severe emotional distress, which is the actual and proximate cause of the injury. Trespass to land. The intentional entry upon the land in possession of another, which is the actual and proximate cause of the injury. Interference with contract. The intentional interference with an existing contract causing damage. Interference with prospective advantage. Defendant intentionally interferes with plaintiff's prospective economic advantage. Intent. One of the following: substantial certainty, desired result, transferred intent. The defendant's wrongful intent is transferred from the intended victim to the actual victim, or from the intended tort to the committed tort. Damages. General, personal, or property damage. Special is lost medical, hospital bills, wages. Punitive, to punish the defendant for his wrongdoing. Okay, so here's another one I found that I did not create. Let's see, defenses to intentional torts. Okay, so you want to remember defenses to intentional torts. How are you going to do that? Well, here's the sentence. There's going to be 13 points here, and I'm going to say 13 words that are going to trigger you. So it's crazy, silly, double, dealing, dirty, dog, leave, right, now, never, return, ever, silly. So it's consent, self-defense, defense of others, defense of property, discipline, detention for investigation, legal authority, re-entry to land wrongfully withheld, necessity, public, necessity, private, recapture of chattel, wrongfully withheld. 12. Entry to abate a nuisance, shopkeeper's privilege, consent. The actual and apparent permission or implied by law, for example, an EMT. Not effective in the scope of consent, exceeded or obtained by duress, fraud, mistake, or consent to illegal act, mutual combat, or illegal intercourse, may be inferred from custom or from existing relationship. Invalidation of consent. Incapacity. An individual without sufficient mental capacity due to insanity, retardation, drug, alcohol ingestion may not legally consent. A child, depending on age, may consent only to less significant matters. Action beyond the scope of consent. Consent is invalidated if the action goes beyond the consent manifested. Failure to inform a patient of the risk of a procedure is treated under negligence. Fraud. Fraud is invalid if induced by fraud that misrepresents an essential aspect of the interaction. Duress. Consent procured under immediate physical harm is invalid. Economic pressure does not negate consent. Illegality. A person cannot consent to a criminal act. Consent is always invalid. Traditional. A person can consent to a criminal act for purposes of tort liability. Consent is still valid except where the criminal law is specifically designed to protect members of the victim's class. Restatement. Self-defense must have had a reasonable belief imminent physical harm or reasonable force used to repel attack. No duty to retreat unless plaintiff had mistaken D's identity or acted without intent. No privilege if danger has passed or if force was excessive. Deadly force privilege where plaintiff believes in danger of death, serious bodily harm, but duty to retreat. Restatement 70, minority view, but not from the plaintiff's own dwelling. Reasonable defense of others. Reasonable force to protect any third person from immediate unlawful physical harm. Majority step in the shoes of the victim. Minority. Reasonable mistake protected. Defense of property. Non-deadly reasonable force to prevent a tort against defendant's real or personal property, where plaintiff is not privileged, where force necessary to terminate the intrusion and demand is made. Deadly force only where your life is in danger. No privilege to expel non-threatening intruder, if to do so would expose plaintiff to greater danger. Reasonable mistake is not protected. Common law allowed deadly force only when needed to prevent the intrusion of defendant's own dwelling. Discipline. Reasonable force by one in loco parentis, acting in place of the parent with plaintiff. Detention for investigation. Merchant's privilege allows stores to use reasonable force to detain plaintiff for a reasonable period of time to investigate possible theft based on reasonable grounds. Reasonable mistake is allowed as long as the store acted reasonably. Legal authority. Felony. Police officers must have reasonable grounds to believe felony has been committed and that the plaintiff arrested has committed it. Reasonable mistake is protected. Force must be reasonable. Deadly force allowed if the plaintiff poses an imminent threat to society or the officer. Private citizen must have a reasonable belief that plaintiff arrested committed actual felony that was in fact committed. Misdemeanor. Police officer is privileged to arrest if breach of peace exists and defendant committed offense in party's presence. Private citizen is privileged to arrest if breach of peace exists, a misdemeanor actually committed, and P committed the offense in party's presence. By the way, if I'm talking too fast, you can slow down or speed up this YouTube video. Reentry of land wrongfully withheld. No privilege exists to use any force majority. Reasonable force to regain possession minority. Necessity private. Private necessity exists where defendant appropriates or injures a private party interest to protect a private interest valued greater than the appropriated or injured property. Incomplete defense. Defendant is privileged but liable for damages. Necessity public. Public necessity exists when defendant appropriates or injures a private property interest to protect the community. Complete defense. Defendant is privileged and not liable for any damages. Recapture of chattel wrongfully withheld. Defendant may use reasonable force to recover property defendant is entitled to when in hot pursuit of plaintiff. Reasonable mistake is not protected. Defendant may enter another's land to recapture chattel as long as entry made in reasonable manner using reasonable force. Complete defense, defendant is not liable for any damages. Entry to abate a nuisance. Defendant is completely privileged to invade the land chattels of another for the purpose of abating a private nuisance created or maintained on the land chattels, as long as the defendant is the owner-possessor of the land chattels injuriously affected by the nuisance. Defendant must first make demand that the nuisance be abated unless impracticable or useless, and must enter at reasonable time and use only reasonable force to effect the abatement. Shopkeeper's privilege. A shopkeeper may detain temporarily for investigation upon reasonable grounds, reasonable force, reasonable belief person has taken his goods. Defenses to general intent. Strict liability. Mine torts. This is just a recap. Mine torts, misrepresentation, intentional versus negligent, defamation, private. Okay, physical torts, trespasses, chattels, trespass to land, assault and battery, conversion, nuisance, private versus public, intentional and to the point of physical symptoms. So you can actually have a physical tort for emotional infliction of distress if the person is vomiting or they faint and they're having physical symptoms. Wrongful death, intentional, malice, unintentional, reckless, negligent, products liability, third-party liabilities and rights, damages, and remedies. So you can, this is another idea if you want to just go even smaller and just have 7 points. But anyway, so for torts, negligence, the definitions follow. Negligence, the defendant's breach of duty of due care owed to the plaintiff, which is the actual and proximate cause of the plaintiff's damages. Duty, standard duty of care. Conduct which is measured against a reasonable person under the same or similar circumstances. Duty, special duty, imposed by statute or case law, which may be in addition to or in place of the standard duty of care. Trespasser. Land occupier has a duty to exercise reasonable care to warn known trespasser of artificial conditions that involve risk of death, serious bodily harm. Attractive nuisance. Land occupier has a duty to exercise reasonable care to warn, protect children from artificial conditions that involve risk of death, serious bodily harm. Licensee, social guests. Land occupier has a duty to exercise reasonable care to warn a licensee of known dangerous conditions. Invitee. In addition to the licensee requirements, land occupier must inspect for and repair dangerous conditions. Modernly, courts apply negligence principles as opposed to the titles of trespasser, licensee, or invitee. So, breach. Failure to exercise the duty of due care owed to the plaintiff, consider re ipsa loquitur. Causation. Plaintiff must show that the defendant is the actual and proximate cause of the plaintiff's damages. Actual cause. But for the actions of the defendant, the harm to the plaintiff would not have occurred. Thus, the defendant is the actual cause of the plaintiff's damages. Proximate cause. It is foreseeable that the actions of the defendant would cause harm to the plaintiff, thus the defendant is the proximate cause of the plaintiff's damages. Intervening cause. An event that comes between the initial event in a sequence and the end result, altering the natural course of events which might have connected wrongful act to an injury. Dependent intervening forces. The foreseeable responses to the defendant's actions. Independent intervening forces, forces which act upon the defendant's negligence but are neither a response nor a reaction thereto, unforeseeable results. Supervening cause, an unforeseeable intervening cause which may relieve the defendant of any liability. Damages. Plaintiff must show actual damages to person or property. General damages, awarded for pain and suffering stemming from the plaintiff's damages. Special damages, awarded for all economic expenses stemming from the plaintiff's damages. Medical, lost wages, for example. Contributory negligence. Plaintiff's contribution to their own injury is a complete bar to recovery. Now, there are only a few contributory negligence states left where even if somebody did 1% contributed, like for example by being in the location where the injury occurred, they are barred from recovering anything. So that's not in a minority. I think there's Louisiana, Virginia, just a few holdout states, maybe 5. Okay, last, and I think one of them is Washington, D.C. Okay, last clear chance. If the defendant had the last clear chance to avoid the plaintiff's injury, plaintiff may recover damages. Comparative negligence. Portions of the negligence of the plaintiff and defendant accordingly. Pure comparative. Plaintiff may recover a percentage of their damages even though their negligence exceeds that of the defendant. Partial comparative. Plaintiff may be barred from recovery if their negligence equals or exceeds that of the defendant. Assumption of the risk. A complete bar to recovery for a plaintiff who place themselves at risk with knowledge and acceptance thereof. That's often used in the contributory negligence argument. Negligence per se, statutes with which create a specific duty of care so that violation of the statute may be established both a duty and a breach in negligence actions. Violation of a statute intent by legislator to protect a class of plaintiff from a specific type of injury. Negligent infliction of emotional distress. NIED. Courts will allow a plaintiff to recover damages for emotional distress if the defendant's conduct results in physical contact or if the plaintiff was in the zone of danger. Bystander rule. In NIED, a person may recover for emotional distress at seeing another person in the zone of danger injured. Joint and several liability. Liability which may be apportioned among 2 or more parties. Contribution. Joint tortfeasors are required to pay their apportioned share of damages. Indemnity. A defendant who is sued and forced to pay a judgment is entitled to indemnification against the joint tortfeasor who is primarily responsible for causing the injury. Vicarious liability. One who is liable for the actions of another based on the relationship between the parties. Respondeat superior. Employer is vicariously liable for the torturous acts of their employees within the course and scope of employment and for failure to exercise reasonable care in hiring, training, supervising their employees. Independent contractor. Generally, employers are not held responsible unless independent contractor is involved in an inherently dangerous activity. Joint enterprise, an undertaking by 2 or more persons as a result of which one participant's negligence may be imputed to the others. Permissive use, granting authority for the use of, as an example, a vehicle. The owner of the vehicle may be held liable for torturous acts of the borrowing user, assault, intentional placing of another in apprehension of imminent harm, or offensive touching without privilege or consent. Battery, intentional, harmful, or offensive touching of another without privilege or consent. Conversion, intentional exercise of dominion and control over another's personal property of another without the privilege or consent. False imprisonment, intentional, unlawful physical or psychological confinement of another without privilege or consent. Intentional infliction of emotional distress. IIED, intentional and outrageous conduct by the defendant which causes severe emotional distress in the plaintiff. Trespass to chattels, intentional interference with the personal property of another without privilege or consent, trespass to land, intentional entry upon the land in possession of another without privilege or consent. Transferred intent. Liability transfers from intended plaintiff to actual plaintiff of an unlawful act actually committed. Product liability. Manufacturers are liable for all foreseeable plaintiffs which will result from a defect in the design, manufacture, or wording of products they place in the stream of commerce. A plaintiff may seek recovery under the theories of strict liability and tort, implied warranty, or negligence. In products liability suits where there must be a proper plaintiff and a proper defendant, head note, or identify who they are and move on. Strict liability and tort. Any party who causes a product to enter the stream of commerce or pass it along may be held strictly liable. Liability imposed without regard to fault. Implied warranty. The assurances applied in law that the product is generally fit for normal use, UCC 2314, and where a seller knows of a purchaser's intended use, fitness for a particular purpose. Negligence. A defendant's breach of duty of due care owed to the plaintiff, which is the actual and proximate cause of the plaintiff's damages. Duty. A manufacturer has a duty to inspect for and correct defects in design, manufacturing, and warning. Breach. Failure of the product to meet the expectations of a reasonable consumer demonstrated by defect in design, manufacturing, or warning. Re ipsa loquitur. The thing speaks for itself. Consider this under negligence as well. When the plaintiff's harm would not have occurred but for someone's negligence, the source of negligence is within the scope of the duty of care owed by the defendant, and the plaintiff or a third party had not caused the plaintiff's harm. Breach may be inferred. Causation. The plaintiff must show that the defendant is the actual and proximate cause of the plaintiff's damages. Actual cause. But for the product's defect, the plaintiff's harm would not have occurred. Thus, the defendant is the actual cause of the plaintiff's damages. Proximate cause. It is foreseeable that a product's defect would cause plaintiff harm. Thus, the defendant is the proximate cause of the plaintiff's damages. Consider intervening cause. Damages. Plaintiffs must show actual damages to person or property. General damages awarded for pain and suffering stemming from the plaintiff's damages. Special damages awarded for all economic expenses stemming from the plaintiff's damages. Contributory negligence. Plaintiff's contribution to their injury is a complete bar to their recovery. Less clear chance. If the defendant had the less clear chance to avoid the plaintiff's injury, the plaintiff may recover damages. Comparative negligence apportions the negligence of the plaintiff and the defendant accordingly. Pure comparative. Plaintiff may recover a percentage of their damages even though their negligence exceeds that of the defendant. Partial comparative. Plaintiff may be barred from recovery if their negligence equals or exceeds that of the defendant. Assumption of the risk. A complete bar to recovery for the plaintiff who placed themselves at risk with knowledge and acceptance thereof. Misuse of product. Item. A party who uses a product not as intended shall not have a cause of action in product liability. Alteration of product. The alteration of a product after sale removes liability of the manufacturer. Design defect. The product was designed in such a way that it presented an undue risk of harm in normal use. Manufacturing defect. The product does not conform to the manufacturer's own standards. Warning defect. Inadequate instructions, warnings, labels, etc. Nuisance. Private nuisance. Defendant's non-trespassory interference with plaintiff's enjoyment or use of their land. Nuisance. Public. Defendant's interference with the public's enjoyment use of public property. Recovery for a party is based on a showing of special harm unique from that of the general public. Defamation. PUD. A false defamatory assertion of fact which is published to a third person understood as defamatory by that person and causes damage to the plaintiff's reputation. Consent is a complete defense. Defamation. Truth is almost a complete defense based on the scenario in the fact pattern. Privilege. Absolute complete defense for the official government scenarios within the core scope of duties and discussions between the spouses. Conditional. Complete defense under good faith. Privilege can be lost by bad faith or abuse. Slander per se. Club. spoken defamation regarding crime of moral turpitude, loathsome disease, imputing unchastity of a woman or a business, injurious falsehood, false injurious statement that discredits or distracts from the reputation of another's character, product, or business, interference with prospective economic advantage, intentional damage, intrusion on another's potential business, relationship, opportunity, or employment, general damages awarded to plaintiffs and suffering stemming from the plaintiff's damages, special damages awarded for all economic expenses stemming from the plaintiff's damage, nominal damage, a declaration of the plaintiff's rights, and a determination that the defendant has wrongfully infringed upon them. Punitive damages, a sum of money in addition to the compensatory damages to punish the defendant for willful, wanton, or malicious conducts and to deter such conduct. Strict liability imposed without regard to fault. Animals, dangerous animals. The injury must be from the dangerous propensity of the animal. Zoos and common carriers are exempt. Abnormally dangerous, ultra-hazardous activities foreseeable plaintiff as they apply to the propensity of the abnormally dangerous, ultra-hazardous activity. Defense of self, reasonable force necessary to protect oneself, up to and including the use of deadly force. Defense of others, reasonable force necessary to protect others with whom the defendant has a special relationship, up to and including to the use of deadly force, moderately to protect anyone. Defense of property, reasonable non-deadly force necessary to protect one's chattel. Necessity, a person is privileged to enter land, interfere with the chattels of another if it is necessary to protect a person from death or seriously bodily harm. Thin-skulled plaintiff. Defendant is liable for a plaintiff's unforeseeable and uncommon reactions to the defendant's act. Guardian ad litem, usually an attorney appointed by court to appear in behalf of an incompetent party or a minor. Immunity. Traditionally, the government units were not subject to suit unless they had already consented to such. Firefighters rule. Police and firefighters are barred from pursuing recovery against those recused as injury during a rescue or occupational hazard of the job. Emergency doctrine. Non-professionals exempts a person from the ordinary standard of care if the person acted instinctively to meet a sudden and urgent need for aid. Good Samaritan law. Professionals exempts liability. A person such as an off-duty physician who voluntarily renders aid to another in imminent danger but negligently causes harm while rendering such aid. Misrepresentation, making a false representation, in fact, without regard to truth, intended to induce a party to detrimentally rely upon it. Balance, the measure of competing interests, an appropriate offset to achieve the balance. Pre-existing duty, a duty which one already has legally required to perform. Okay, that's the main ones. Thank you. Bye.